Hi, everybody. I'm Steve Paikin, and we are at the National Arts Centre in Ottawa, in the Peter A. Herndorf Place. We are happy to welcome you and our live audience for this edition of TVO Today Live. Our topic, Democracy and Canada's Supreme Court. This series is made possible by the generous support of the Wilson Foundation, so that we can explore vital issues facing our shared democratic institutions. Red Wilson, as always, thank you so much for making this series happen. I have had the good fortune over the years to have interviewed tens of thousands of people in 40 plus years of journalism, but I have never, until now, been able to say the following words. Ladies and gentlemen, please welcome the current Chief Justice of Canada, the Right Honourable Richard Wagner. S'il vous plaît. So nice to meet you.
All right.
Yeah, so that's
And by the way,
cool.
happy birthday, Steve.
You All right. Thank you, I think. We are, first of all, as I suggested in the intro, very pleased that you've agreed to come on this program, to take questions from us, to take questions from the audience. And I'm going to start with a very simple question, and that is, how did you get the job?
Well, I hope it was because I was supposed to do a good job. But, I've been, first of all, I was a lawyer for 25 years. I practiced law for 25 years in Montreal in civil and commercial matters. And then I'll make it very short. I became a judge of the Superior Court, which is the 12th division in the province of Quebec for between 2004 and 2011. And then I went to the Court of Appeal for almost 2 years, a little less than 2 years, up until 2012. And then I became a judge at the Supreme Court since 2012.
I'm going to make a suggestion here. I've unbuttoned my jacket because it just looks and feels easier.
Okay.
And I think
Thank you very much.
You should too. And just give your tie a little pull down as well.
Okay.
There we go.
Thank you.
Good. I want him to look good, you know?
How's the hair?
The hair is great.
Okay.
67 and look at that head of hair. Not bad, eh? Not bad. Is the Supreme Court, is the Chief Justice of Canada a job one applies for, campaigns for? How does that work?
Well, you don't campaign for, but...
Behind the scenes at all?
Not at all, not at all. We have a good system here in Canada. It's very different than in other countries very close to us. And we have a good judicial independence. And the way to be appointed to become Chief Justice of Canada is, first of all, it's the decision of the Prime Minister. Mm-hmm. And the Prime Minister will consult and will decide who would be the best candidate to fill the job. All the other positions at the Supreme Court of Canada, to be what we call a puisné judge at the Supreme Court, of course, the candidates have to apply, that's for sure. And the candidates are evaluated by an independent committee made of several people. And that committee needs to suggest to the Prime Minister, recommend to the Prime Minister 3 to 5 names. And the Prime Minister has to choose from those names. So it's very transparent, very different than other systems. Maybe not the perfect system. There's no perfect system, but I think it's one of the best.
And he can't go off that list and just pluck another name out of somewhere else?
No.
Got to be from that list?
Yeah.
Okay. What kind of paces do they put you through? For example, we have seen in the United States, when the president recommends a judge for the Supreme Court, they go through quite a bizarre set of hearings in front of senators and so on.
Yeah.
Do we have that here?
Well, it's no. The short answer is no. We have a very civilized, I would use the word civilized process, more transparent process as well. The process to become a judge of the Supreme Court and all of the other courts, federal courts in Canada, is different than to become Chief Justice of Canada. So to become a judge at the Supreme Court, you have to apply. You have to file an application, which is made public at the end of the day when you're chosen. And you have to mention all what you've done in your career as speeches, judgments that you released, conferences, and so on and so forth. And the committee will look at the applications, will have interviews with some of the candidates.
So you've been grilled.
No, at my time, it was not like that. It became like that just a few years after. At my time, during my time, I had to apply. And then the Prime Minister had to choose amongst the candidates who applied.
Would you like to see a system that is more like the United States, where we really give judges a good grilling in public, on television, and it's difficult?
No. but you know, we have to be fair, and I don't want to criticize another country's system. We're so different, Canada and the US. We're two different countries. We have two different ways of looking at the judiciary. We have a strong judicial independence. We have ethical principles in Canada, which were adapted 2 years ago. They were created in 1988, and we looked at it once again a couple of years ago to take into account the new reality in which judges are working. Internet does not exist in the past. Social media in 1988 was not as present as they are today. Judges did not retire as soon as they do today, very young, for most of them. So they have a third career afterwards. So what do you do in that period? So we had to adapt our ethical principles to the new reality, social context.
They don't have that down south, do they?
No.
There's no code of conduct.
I understand that the Supreme Court recently adopted some kind of ethical principles, but that has nothing to do with ours. And our ethical principles apply to all federal judges in Canada. And I know that provincial judges also have to follow ethical principles. That's a big difference. The mode of the process to appoint judges is very different. In the US, they have elected judges at the lower court level. And here in Canada, the judges have to apply. They are looked at by an independent committee who will make recommendation to the Justice Minister or to the Prime Minister. So it's very different. And that's why I don't think that system would come to Canada.
Vive la différence?
Vive la différence, yes.
Okay. Could you take us through a typical day? What do you do in a day?
There's no typical day.
Is there a typical week?
Not even. Okay. It depends whether, if you're asking me the question as Chief Justice, because as Chief Justice, I wear different hats. As a matter of fact, I wear many hats. First of all, as a judge, just like my colleagues, I have to hear cases and write judgments. And I remind my colleagues very often that's our first obligation as a judge of the Supreme Court, to hear cases and prepare judgments. And then as Chief Justice, of course, I have other responsibilities. I have to manage the court. There are 250 employees at the court. That's a lot of people. We have a registrar, deputy registrar, but still at the end of the day, I'm the one responsible for the court. And as Chief Justice, I also wear the hat of chair of the CJC. The CJC is the Canadian Judicial Council, which is made of the 44 Chief Justices and Associate Chief Justices in Canada, in every province. And we meet several times a year to look at different issues. We are responsible for the discipline of judges when there's a complaint against a judge. We supervise also the training of judges as well. So we meet quite a few times. We have working groups, many committees also working on different issues. And I'm also the chair of the National Judicial Institute, l'Institut National de la Magistrature, which is the organization that creates and set up the professional training for judges. It's a very professional organization, and the NJI not only provides training for judges in Canada, but provide also training for judges outside of Canada.
There's another thing on the list you had to do as well. You were Governor General for a while.
Yeah, well, that does not happen often, but
thankfully,
But there are two things. According to the law, the Chief Justice of Canada becomes or can replace the Governor General when the Governor General is unable to attend a function or do something. So I've done that before. But what happened a few years ago is that the position became vacant. In other words, the Governor General resigned. That's a different story. Then there's no more Governor General. And according to the law, the Chief Justice becomes what we call the Administrator of Canada. In other words, it's like the Governor General, but the title is Administrator.
And did you have to sign every bill before it became law? You did.
For 6 months. So I was told at first that, don't worry, the Prime Minister asked me to fill the position with the clerk of the Privy Council, and they told me that it would be for a short period, 6 months.
So, not so short.
Well, my fear in those days is that it was a minority government. And the Governor General sometimes may be called to decide if there's a vote on non-confidence in Parliament. The Governor General will decide who will form the government. That's something I didn't want to decide.
No, come on.
That's not my job.
But be honest, deep down a little bit, you were hoping there'd be a huge constitutional crisis and you'd be on the hot seat.
Trust me, no. Okay. So, but we were fine. There were no issues on that side. But it was a good opportunity for me to know more about the civil service, the civil servants, the Privy Council, and to what extent we have very strong institutions. The counterweights are everywhere. So to avoid tyranny or to avoid some kind of dictatorship, that's how I was very comfortable with discovering all those issues and the good staff also working for them.
It sounds, though, like with all of those different responsibilities that you have, hearing cases and writing judgments is not even the majority of the time that you spend. Is that right?
Well, sometimes, maybe you're right. Maybe you're right, because I have two more hats I would like to talk to you about.
Oh, two more hats?
Yeah. So one more hat is that I chair the Advisory Council for the Order of Canada.
Okay.
That you received, by the way. So a few times a year, we will, together with my colleagues, 11 members, we will look at the applications, hundreds of applications of citizens who deserve to be honored for their work as Canadians, for what they've done for Canada. And it takes quite a few hours to look at those applications, and we make recommendation to the Governor General for the Order of Canada. One more hat. Because of COVID in 2020, everything stopped in Canada, and the courts also stopped. The buildings were closed suddenly. And so during the month of March, I phoned the Minister of Justice, Mr. Lametti, and we agreed that we had to do something because there were some urgent matters to be dealt with at the court, alimonies, custody of children, criminal trials, and everything had been stopped. So we set up a special committee, which was called a special committee for the resolution of the work of the court, something like that. And the purpose of that committee was to find ways to help the courts to reopen and facilitate access to justice. And we're meeting for once a month. And on that committee was chaired by me, the Minister of Justice, and also Attorney Generals. There were some Chief Justices, there were civil servants. So we worked very hard to find ways, guidelines, tip sheets, to help the courts to reorganize. And now that COVID is behind us, we decided that we will still meet, but the mandate has been changed.
To what?
Well, to facilitate access to justice.
Do we have a problem with that right now?
Big problem. And it's a work in progress. I think it's going better than before, but we have to still work to facilitate the access to justice.
You have an annual news conference every year in which you make an opening set of remarks and then you take questions from journalists. Are you the first to do this, incidentally?
Yeah.
Okay.
But
so you did it earlier this month, and one of the things that you did raise is that you and your provincial colleagues have found there to be not nearly enough judges in the country. to hear cases, to render judgments, and therefore give the public the impression that they are entering a good and useful and effective justice system. How close are we to where you think we need to be if we're not there?
Well, it's a work in progress. So, the justice system in Canada, just like in most countries where governed by the rule of law, democracies, the legal system was always the parent pauvre. In other words, governments always invested in health and education, which is great, but the justice system was always on the side, and they did not invest so much. That's why, after so many years, it created so many problems, like delays, cost, and lack of judges, and lack of facilities, and lack of technology, and underpaid assistants, underpaid secretaries, and so on and so forth. It's the same everywhere. But and that brought the Supreme Court to decide the case of Jordan, for instance, where we said it has to stop. An accused has the right for a criminal trial within a reasonable delay. That's what the Charter of Rights says.
And you've decided a reasonable delay is?
It would be 30 months.
30 months.
And then the governments reacted and then started to invest in the justice system, in technology and appointing other judges and new judges. But there is still a lot of work to be done.
Do you worry that, I understand you're inside the system, you see how it works, you see what the failings are, you want to address them. But of course, politicians and governments get a lot of advice from a lot of people. Do you worry when you do this that you are seen as just yet another lobby group looking for something from the Prime Minister's office or the Premier's office?
Well, I don't know. We'll have to ask the questions to those people. But insofar as I'm concerned, as Chief Justice of Canada and Chief Justice of the Supreme Court, I have a responsibility, which is, by the way, mentioned clearly in our ethical principles, to speak up on issues that have an impact on the justice system, judicial independence, and democracy. And I do it in a very positive way. There's a separation of powers in Canada, executive, legislative, and judiciary. And we don't get involved in politics. We don't get involved in the executive, and the executive should not get involved in the judiciary. That said, that doesn't mean that we cannot cooperate and we cannot collaborate, and that's what we do.
You've mentioned the expression judicial independence several times already, and we've only been talking for 10 minutes, so I know this is important to you. So I'd like your view on what you think when, for example, you hear the Premier of Ontario, Doug Ford, say things like, well, of course I'm going to appoint like-minded judges, people who think the way I think. What does that do to you?
Well, I will not address this case in particular. But I will tell you that Canada is not a superpower in terms of military or economic, but I think Canada is a superpower in terms of democratic values, and one of those democratic values is judicial independence and the rule of law. And in that sense, I think that in order to have a good democracy, you have to respect the judicial independence. And I think that overall, it's going well in Canada when you compare with other countries very close to us. And because people respect that, people are attached to those values. And I think that we should make sure that everybody, all the stakeholders in society, whether it be the elected officials, whether it be the media, whether it be the judges themselves, should make sure to support judicial independence and democracy.
How are you defining judicial independence?
Judicial independence, it's not for judges. Judicial independence is for the people. It's to make sure that the people, the citizens, who are going before a judge will be sure that they will be heard by a man or a woman, a judge, who is impartial and independent. That's what judicial independence means.
Independent of what?
Independent of any influence. That no government should have any, no lobby group should have influence on judges. No government should have any influence on judges. And that's essential to to make sure that the people keep their trust in the judicial system.
How would you rate the trust of the Canadian population right now vis-a-vis its court system?
I think it's very good. I saw a survey of last year, of Léger survey 2023, and I think that 2/3 of Canadians, for instance, had trust in the Supreme Court of Canada. I think in the province of Quebec, I think it's 74%. Distinct society, I guess. But the support and the trust is very high compared to other countries very close to us.
That's twice you've said that one too.
Because we're neighbors, you know.
Yeah. So when an Ontario court judge walked into court one day and put a Make America Great Again hat on his bench, was that a bit of a departure from judicial independence?
Is that an actual case?
That's an actual thing. That happened.
Okay. So maybe it's before the courts. Maybe there was a complaint. Maybe
there was a complaint.
Okay, so then I will not comment on that.
Oh, damn, I shouldn't have said that then. Yeah. Well, okay, where am I going to go here now? Let's talk about another country that may be close to us and see, since you seem to be enjoying making the comparisons here. We have seen a Justice of the United States Supreme Court with an American flag hung upside down on his front lawn. We have seen the wife of a current member of the United States Supreme Court send text messages to the Chief of Staff of the President of the United States on the 6th of January, 2021, saying, hang in there and, stop the steal and all of this business. This does get back to the notion of how much we can trust judges to be judicially independent. What do you think that does?
Well, I think it doesn't help, that's for sure. And that situation could not happen in Canada.
Why do you say?
Because all the judges are governed by ethical principles, as I mentioned before. And according to those principles, no actions like you just described could be done by a judge or even the family of a judge.
Well, we had a MAGA hat on the bench. That did happen.
And we'll see how it goes.
I don't have to tell you, we get so much of our information and news flow from south of the border, so much so to the point where I think a lot of people wonder whether our judicial system is as it's portrayed on Law and Order. And I don't mean the Toronto version, I mean the American version. How much of a problem is that for you as you try to establish your own set of values and independence from that onslaught of whatever that is?
I think it's going well in Canada, that's for sure. We'll have to say it, We have to mention what's going well and what's not going so well, but that's going well. But we have to be mindful and we have to be vigilant. And, I was invited a couple of weeks ago in Brazil. They were holding the G20 summit. The G20 summit is the summit of all the chief justices of all the countries of the G20, which will be held in Brazil in the fall. And everybody was there except Japan and the US. The US never goes to those type of summit. And it was very interesting. I had China just beside me and Russia right in front. They were kind of silent about democracy and about the rule of law, but all the other chief justices spoke about disinformation. And in Brazil, it's such a problem that the Supreme Court of Brazil had its own program to fight disinformation, misinformation. And so we discussed about that because it might be a problem. It happens sometimes here in Canada, but in a very few circumstances, but we have to be mindful of that. And when I looked at their program, the Brazilian program to counter disinformation, it's based on providing good information, finding ways to make sure that people understand the work of the court and so on and so forth. And when I read that, I said to myself, well, I think we were not so bad at the Supreme Court of Canada, because that's exactly what we've decided to do since I became chief 7 years ago, to make sure that people would understand our decisions. So we have this case in brief. On one page, we summarize the essential elements of a decision that can have 200 pages. It's not easy to write short. It's easy to write long, but short is not easy. but it facilitates the understanding of our decision. And at first, it was made to make sure that Monsieur, Madame, tout le monde, the public in general, without any legal background, could understand our decision. We discovered, with a survey, that it is used by the media a lot, by law professors, by judges, and hopefully it could be used eventually by elected officials. And it's a great success.
So you think it makes the courts more accessible?
I think so. Yeah. And the initiatives that we got, that we've done to have the courts sit outside of Ottawa. We went to Winnipeg in 2019, and 3 years after, we went to Quebec City for 1 week. We heard 2 cases at the same time. We met with the high school students, the 9 of us in 9 different schools, answering questions for an hour and a half. We met with the general public at the museum. We met with the Métis people. We met with the Indigenous people. We met with the law students. So people were lining up in the morning at 6:30 in the morning to have a chance to get into the courthouse. So there was a need, It's not everybody who can come to Ottawa to attend hearing of the Supreme Court. So it was one way, small remedy, but one way to make sure that people would understand how the court works. It's very difficult to appreciate and like something that you don't know, right? So the best way to make sure that people will keep their trust in their institutions is to make sure that those institutions are well known by the public.
Well, let me follow up on that. Your cases, when you hear cases, they are televised, which is very interesting. Do you think it would be in the interests of justice to have more courts with television in the courtrooms?
As a principle, I would say yes, but it's a different story when you don't have witnesses and the parties. And so at the Supreme Court, you don't have witnesses, you don't have the parties themselves, only lawyers arguing on the file. So there's no confidentiality issues or security or safety issues, which you can see and have in the trial courts, for instance, where you want to protect the identity of witnesses, for instance, or the victims. So we don't have that same challenge at the Supreme Court and at the Court of Appeals across the country. But I think it's a good way to make sure that people can see. It's the open court principle. People could see what's going on in a court of law, and we've been doing that since 1987. Yes. So we were one of the first court in the world, Supreme Court in the world, to do it.
Let me just do a little business here and remind everybody that we are in the nation's capital at the National Arts Centre, and our guest for this edition of TVO Today Live is the Right Honourable Richard Wagner, who was the 18th Chief Justice of Canada. And with that, I want to hearken back to something you said earlier about your role in democracy, the judicial, the executive, the legislative. You are one of the 3 significant arms of our democracy. I don't know if politicians ever tell you this off the record, which is why I want to ask you about it now. Do you ever find them saying to you, you know what, we could never do this, or if this law gets overturned, it would do us a great service because our base will have a terrible time with this law if we pass it, but if you find it unconstitutional, you'll really get us off the hook here. I mean, you know that happens in our democracy. Do they ever tell you that? Do they fess up?
They will never try to, I'm sure. But they may think about it.
They definitely think about it.
They may think about it. Yeah. But that's, in French, we say un procès d'intention. So I will not go there. But, we take the files as they are presented to us. We don't look for files. And there are 3 ways, according to which the court will decide a case. It's by leave applications, it's by as of right, or by reference, where governments will ask us an opinion on legislation. But they never tell us that they would appreciate that we give an opinion before,
Well, okay, let's ask about the third one of those, the reference. Yep. This is where a government will go to you ahead of time and say, we're thinking about this kind of a law, or we're thinking about making this kind of a decision, but we're not sure it's legal. So we'd like to present you with the facts and then you tell us. That snuggles pretty close to political involvement, doesn't it?
No, it's a question of law insofar as we are concerned. Those references deal with constitutional issues. And the Parliament has given the Supreme Court of Canada the mandate to interpret the Constitution and the Charter of Rights. And the Parliament, of course, is elected by citizens. So it's a very legitimate power that we exercise to interpret something because Parliament gave us the mandate to do it. So it's within the constitutional aspect of the things, and it's very, very legitimate, I would say.
During your annual news conference recently again, you said, it's absolutely fair ball if people want to criticize the decisions we have made as judges, but it's not fair to criticize judges personally or sort of inquire as to why they may have been appointed. And I want to get a better understanding of that distinction that you make. Pourquoi?
Well, I think that in Canada, we have protection for free expression, and according to our Charter of Rights, and that's very good. That's one ingredient of a strong democracy, to allow people to, state their opinion. The media can state their opinion. They can argue. People should exercise their freedom of expression. If they don't, democracy will suffer. So we need to support that. On the other hand, you need to give the right information. You don't need to discredit the institution. And if you challenge or if you discuss or comment on a decision of the court, that's fair game. That's good. But if you don't comment on the decision, but you comment on the judge who released the decision, that's a different story. Those type of comments will bring disrepute to the institution, and in the mind of the citizens could attack the trust that they should have in the legal system. So I don't think that people should, the media or the elected officials or anybody, should attack the judges when they release the decision. They should attack the decision itself, and that's fair game.
Humor me for a follow-up here. You have an Indigenous judge on the court. An Indigenous judge may hear a case that deals with Indigenous-related issues. There may be Jewish judges on the court who may hear cases as it relates to issues that are of importance to the Jewish community or Israel or who knows what. I could go on and give other examples. If those people are involved in making decisions which side one way or another, which coincide with their own background, are people entitled to ask whether or not their own background had some feature in that decision?
Well, they could ask a question, but they should not try to discredit the decision because of the different aspects of the judges. I always said that in order to increase the trust of the people should see themselves in their institutions, in Parliament, in the big institutions, private or public, and in the courts. And it's one way to make sure that people will keep their trust. So at the Supreme Court of Canada, we now have 5 women, 4 men. It's the first time. That's the first time in history. It's a great thing because it's equality and it represents society. We have also the first Indigenous judge as well, and racialized judge as well. So it's good for credibility of the institution. So people should see that as a great asset for Canada compared to many, many other countries in the world. So it's a very diversified course. Diversity is there, and it should comfort and make sure that people will keep their trust in the institution.
Let me follow up on that, because there are some people who don't believe that all of this diversity is a wonderful thing. And there are people who think it's overstated. And maybe this is an opportunity for you to tell us how a court with a majority of female members on it does business or decides things differently than, say, a court that would have been 8 men and 1 woman.
Well, we do it the same way. In other words, we have to take the file as it is presented, consider the same legislation, the same law, the same arguments. But it's a question of credibility. And we're only 9 judges, We're not 200. So diversity, I think, with 9 judges, I think we're pretty good at this time. But we have different background. You know, there are 3 judges from Quebec. We have judges coming from different provinces, different background, different lived experiences, different language, different culture. And that's very good. That increases, I think, the credibility of the court. And all those people will background, different way of looking at things, will enrich the debate. And I think that when people say, well, you're not all the time unanimous in your decisions, well, thank God we're not, because if we were always unanimous on any legal issue in Canada, we would be in China, in Russia, or in Iran. I mean, we don't want that. So it's normal, people with having different backgrounds to sometimes have different opinions. But on the main legal issues, very often we are unanimous, or there's a strong majority.
I want to give our audience the heads up here. Tina, where's the microphone where people can line up for questions? It will be in the middle. Okay, in just a second, we're going to put a microphone in the middle of the floor. If you want at this time, I'm going to ask a few more questions of the Chief Justice, and then it's your turn. And these questions, I guess these are a little off the beaten path.
Present company accepted, of course.
Who was the most important Chief Justice in Canadian history, in your view?
That's a very difficult question.
Thank you.
Maybe the next one after me.
All right, who was the most influential in your thinking?
I think that, that question was put to me, and it's a good question, but we have to be careful because every Chief Justice in Canada will act according to the environment in which he was appointed. In other words, when Justice Dixon was Chief Justice, there were no social media. When Lamère was appointed, the situation was different also on various aspects. So it's unfair, in a way, to compare the period according to which a Chief Justice will act with another period of another Chief Justice. I think that every Chief Justice has to be looked at according to the environment in which he has to preside the court. And it's not easy. We all had and will have our challenges, different challenges.
In America, if you're on the court, the High Court, you can serve for as long as you want.
Yeah.
Here, 75 and you're out. Which is better?
That's not up to me to decide those issues.
But you have an opinion.
Yes, and I'll keep it for me.
Okay. I'm not doing so well here, am I? Yeah.
You're doing very well.
Well, merci, monsieur. I know you don't like to talk about politics, but I'm hoping you're going to make an exception for this next question, because I want to know if you remember where you were on February 22nd, 1976. You were 18 years old. Do you remember where you were on that day?
Yes.
Could you talk about it?
Yeah. You're referring to the convention of the Progressive Conservative Party in 1976. And I was a young student at U of O, Université d'Ottawa. And I was 18 years old, and I was a delegate at the convention.
Why?
Because my father was one of the candidates for the leadership, Claude Wagner. And I remember I voted at that convention, and we lost the convention at the fourth ballot. We were leading for the 3 first ballot. We lost it by 33 votes on 3,000 delegates. So I still remember it.
Just in case this audience does not remember, Joe Clark won it from 3rd place, which had never happened before. Brian Mulroney was also in that convention, and he came 3rd. And your dad almost made it. What's your most powerful memory of that day?
Well, the way he reacted, very noble, very humble, very courageous. And, he died 3 years after.
Yes.
And he was 54 years old. And my father was a model for me in many sense, for many issues. When we talk about public service, he's the perfect example of a person who gave his life to public service. whether it be as elected official, as a minister of justice, as a professor of law, as a lawyer, as a senator. At 54 years old, he had an incredible career, essentially devoted to public service. And I think of him very often because of his courage and commitment to justice.
You have outlived him by a lot. Do you think about that?
Yeah, very often. Yeah, I wish I could sit with him and have a good chat for a few hours and talk about the last few years of my life.
And of course, we just lost Brian Mulrooney this past year, and Joe Clark just earlier this month celebrated his 85th birthday. So they were.
I wish him long life.
Yeah, very good. Okay, Chief Justice, thank you for this so far. We are going to take questions from this audience now, and thank you for lining up and doing so. Yes, sir, you're first.
My name is Adrian. I live just down the street. Thank you for this opportunity. It's great to hear your viewpoints. I'm curious to ask about two things about process, about things you mentioned. So one was independence, and the second is technology. So with regards to independence, I'm curious as to like the feeder groups becoming judges. So as lawyers, I find that environment to be very combative, right? And trying to win one position over the other. And then that role has to switch as you become a judge. I'm curious as your thoughts in terms of how that transition happens for most, going from more of a combative to maybe even a arbitrator or a facilitator. Second, for tech.
Stand by. Let's do one at a time. Sure. Go ahead.
Yeah,
Chief
that's a
Justice.
very good question because I was a litigation lawyer for 25 years. So suddenly you become the one who decide with lawyers arguing a case. But it can be done very easily, although sometimes you would hope that you would go back on the other side of the bench. But it's a question of training. It's a question of realizing that your role is different now, and because of that, because the responsibility that you have, you will make the change quite easily. It's not everybody who can make the change easily. Sometimes it will take more time. You have to realize also that now in Canada, people are appointed as a judge, not necessarily because they were litigation lawyer. It could be law professors, for instance. They could be corporate lawyer. The profiles have changed throughout the years. But essentially, if you were a litigation lawyer and you become a judge, because you were a litigation lawyer, you know where the traps are, where to go and not to go. So for me, it was easy for a change.
Quick follow-up, Adrian?
Second's on tech. So I know you mentioned misinformation. I'm curious just about, even how you're talking about like publishing summaries, right? To make sure that people understand. But if interpreting law is just understanding kind of what happened before, then like AI seems to be very positioned to have a full understanding of what happened before to be able to produce what should be the outcome now. Is there a role for AI in the court system now?
I think there is. It's a very interesting issue because AI is the topic discussed by many, many people in society right now. And I'm sure that it could provide good sides, very positive sides, but also very difficult and damaging problems. And we learned about that, recently, where there was in BC, one lawyer argued a case which did not exist, as a matter of fact. It was produced by AI, but did not exist. So we had the same problems in other jurisdictions in the US and in Europe. So misinformation, disinformation is a danger which could be linked to AI. But it's early in the process now. It's going fast, mind you, but we have to be mindful of the good sides of AI for access to justice. It could be very useful, but on the bad side as well, to protect ourselves against disinformation and misinformation as a result of AI.
Understood. Yes, sir.
My name is Rick Pringle. I'm from Ottawa. You hear in the political world and the media talk of judicial activism. What is your definition of judicial activism, and what is your perception of it in Canada?
Well, we hear that, or government of judges, or that type of expression. You will hear that expression when a court of law will, for instance, will declare illegal or unconstitutional a legislation. And then people will say, well, you know, they're acting like government, the government by judges. But when we uphold the legislation, well, we're doing only our job. So you see how it can color the way you look at that expression. So I'm not concerned about that. I think we're doing our jobs. Of course, as we mentioned before, there are some very difficult issues that Parliament will not deal with, but that the judges need and have no choice but to deal with because of the way our constitution works. So does that make us judges, government? No. We simply exercise our discretion as given by Parliament.
You can't really punt an issue, can you?
No.
It comes to you, you're stuck with it.
We have to decide.
Yeah.
We have to decide.
Yeah. Yes, sir.
Hello, my name is Rendra Singh. I'm from Ottawa, and my background has been for many years in human rights. I refer to Bill 21 that was passed a while back in Quebec, and that bill, I forget the terminology, but Quebec chose to exempt itself from the equality provision of the Charter and passed this Bill 21 that has affected the rights of many groups in Quebec. For example, a Muslim lawyer who wears a scarf has to set aside her aspiration to become a public prosecutor. A Sikh teacher with turban had to move 2,800 miles to Vancouver to carry on teaching, calling herself a refugee in her own country. Similarly, Jewish and other groups have been affected. So when Quebec exempted itself from the equality provision of the Charter of Rights, did the Supreme Court of Canada have any say in the matter at all? Or, I mean, you as the independent judiciary, we all look up to the Supreme Court as a final source of delivering fairness and justice, especially on rights, in equal rights and human rights. So did the Supreme Court make any effort to talk to the Quebec?
Mr. Singh, let me just jump in and sort of remind everybody, 30 seconds of background here. The government of Quebec on multiple occasions has used the notwithstanding clause of the Constitution to set aside those rights in the interests of pursuing the agenda of the day that they want to pursue. I think that's as neutrally as I can put it. And Mr. Singh has a question about whether or not the Supreme Court has a role to play in any of that.
Well, thank you very much, sir, for your question. But no, this question of Bill 21 and the notwithstanding clause, this question is before the court right now. There is an application for leave to appeal, which was presented a few weeks ago. The court has not decided yet on this application, so it may come to the court on the merit, maybe, eventually. And therefore, you will understand that I cannot at this time say anything about that file.
Or back to the, sorry if I can follow up on this, back to the government itself, can it in any way, since the government did not need the permission of the provinces to repatriate the Constitution back, could they not then overrule the Bill 21 if they wanted to?
Again, that's a question I cannot talk about right now, and I would like to be part of the debate eventually.
Thank you.
Thank you, Mr. Singh. Can I just ask a quick follow-up on that? Does the Supreme Court, or do you have a view on the advisability of provincial governments using the notwithstanding clause?
That may come to the court. I cannot say anything about that at this time.
Okay, because I've interviewed some of the latter-day founders of Confederation who were responsible for that notwithstanding clause, Bill Davis being one, Peter Lougheed being another, and their view was, we put that in there as an ultimate safety valve against a crazy court decision, but it was certainly not intended to be used willy-nilly for anything that governments wanted to push through. and they, just because they didn't like a court decision. So I guess I'm wondering, is your view for a more robust or less robust notwithstanding clause?
So those opinions you refer to come from politicians.
Yes.
I'm a judge.
And your point is?
The point is, I will. It's obvious. It should be.
Nous essayons ici, n'est-ce pas? Okay, yes, please.
Hi, my name is Sarah Leanne. I'm from Ottawa, Ontario. My question concerns, we've spoken a little bit about our neighbors to the south today, and over the past number of years, we've seen them question some norms that I think many legal scholars didn't think they'd ever have to question, like, can a president pardon himself, or can a president pardon his son? You spoke earlier that you don't necessarily see such a debate happening in Canada because judges are governed by ethical principles, I think is how you phrased it. I'm just curious if you can speak to the enforceability of those principles, and what safeguards or mechanisms are in place to prevent rogue actors from taking advantage of maybe loopholes or crevices that they to their own advantage. Thank you.
It's a good question. To come back to what's going on south of our border, I've given up to try to explain, honestly. And that's why I concentrate my energy for Canada and for my fellow Canadians. But to avoid what could happen in that country, I think we have as I mentioned to you, and you referred to the ethical principles, they could be enforced. In other words, if a judge in Canada, a federal judge, but they have more or less the same provisions for provincial court judges as well. But for federal judges, if the judge does not respect those principles, there can be a complaint filed against that judge before the CJC and the Canadian Judicial Council. And there's a discipline process that can start, and that judge will be disciplined eventually. So there is a mechanism to deal with that type of issues, which obviously does not exist in other countries.
Thank you. Yes, please.
Hello, thank you so much for coming in today. My name is Luke. I'm from a bit farther away from Ottawa. I'm from Vancouver. And I wanted to ask about reconciliation. Obviously, it's been the issue of the day for quite a few years now. And I wanted to ask about the role of the court in Indigenous reconciliation. What do you see as the Supreme Court's role in furthering reconciliation in Canada?
That's a very good question. I think that all the stakeholders in the justice system has a role to play, but can be different. The elected officials have a role to play, in legislation. But the court, as I mentioned to you before, the Supreme Court, we don't look for files. We take the files that are presented to us. So provided that the file is presented to us, which involves determining the extent of Indigenous rights, the court will decide. So in the process of reconciliation, I consider the court as being part of this process in deciding the issues that are presented to them when they are. So I think that we have a role to play. And for the last, I would say, at least for the last 50 years, at least, the Supreme Court of Canada, when the file is presented to the court with the evidence and the good arguments, the court will not hesitate to recognize existing rights of Indigenous people when the file justify it.
Thank you. Yes, sir.
Yes, my name is John Bensger. I'm also from Ottawa. So I was interested in the ethical principles issue that you brought up. And there was a very good question a couple of minutes ago, but you brought up the Canadian Judicial Council. And so I'm wondering, who appoints people to the Canadian Judicial Council, and what ensures that the Canadian Judicial Council is actually impartial and adheres to those codes of ethics as well?
Well, the Canadian Judicial Council is made of the 44 Chief Justices and Associate Chief Justice in Canada. And within the CJC, there's a special committee which deals with discipline. And the Chief Justice, I have no say in the discipline process. I do not participate in that process to make sure that it is completely independent. And should a case comes to the Supreme Court of Canada, then I would not be obliged to recuse myself. But that said, the independence of the CJC is the same independence than the judges, the chief justices can benefit in their own province. In other words, they are appointed according to the process. Independent committee will recommend a name to the Justice Minister and the Prime Minister. So they are independent and impartial.
Yes, please.
Hi, I'm Madeline. I'm also from Ottawa. You spoke to the diversity of the Supreme Court, which is obviously an amazing accomplishment. But you also spoke to the fact that there aren't enough judges in Canada to carry out the work of the court as you envision it. So what is being done to recruit and retain judges that reflect the population of Canada?
Well, that's a very good question. I think that, as I mentioned before, the justice system did not follow the evolution of society. In other words, there are many more people. The legal issues are more complex, but we did not create more judges' positions for many years. And there was a problem I mentioned last year, that there were some vacant positions. In other words, there were judges who would retire, they would send their letter of retirement, but their positions were not filled before a number of months and even years. So that's why I wrote to the Prime Minister and to ask him to do something about that. I heard last week that, in fact, there was some improvement. And the Justice Minister wrote a letter to me saying that now there's only 57 open positions as for judges, which is an improvement, but it's still, for me, not enough. Any open position should be filled because that could create problems. Because last year, there were some cases that were stayed. In other words, the proceedings in criminal were stayed because there were no judge to hear the case. So, we come from very far. But there's an improvement. I say that people realize the need to do more, but it's a work in progress. We have to keep the pressure.
Your letter to the Prime Minister, was that a public letter or was that a private letter?
No, it was a private letter. It was deemed to be private, but it was leaked somehow. So
Who leaked it?
I don't know. I'd like to know.
You think from his side or from your side?
Good question.
Okay. Well, let me do one. Oh, I'm sorry. Okay, you're at the mic. Let's take you.
Hello, my name is Kimberly. I'm from Ottawa, and I hope I have a pretty easy question for you. You mentioned that to become the part of the judges of the Supreme Court, you had to have training. And I don't know if you said it was 6 months for your training. What exactly are you trained in? Because at every level of the judiciary, you will get some training. By the time you get to the Supreme Court of Canada, you have a fairly wide variety of cases you may have heard. So can you go into a little bit more about how you were trained? And I imagine they don't give you exams with pass and fail during it.
So maybe I misspoke because there was not a training as such. I worked as a litigation lawyer for 25 years. I was in court almost every week in all kinds of area. I went to the Supreme Court for the first time in 1983. I was 26 years old. And then, having worked for 25 years, I filed my application to become a judge because there was some kind of circumstances behind that, but I thought it was time to do something else. And I felt that I could do the job, and I filed my application. I was appointed. And then, as a judge, I presided trials not only in civil, commercial, but also in criminal matters, because criminal law was very interesting to me since I left the Faculty of Law here in Ottawa. But you cannot practice in criminal law and practice in commercial law at the same time. It's a very specialized practice to be a criminal lawyer. But when I became a judge in 2004, I said to myself, this is my chance. And because I always loved criminal law, and I could never practice in criminal law. And then following my appointment, I followed the training in criminal law, all the training session that was available in Canada in every province. I followed it for a year and a half, 2 years. And then I became to preside jury trials. And at the end, when I was appointed to the Court of Appeal, I was only doing criminal law, which is fascinating because you can judge of the nature of society because of the criminal law. And then went to the Court of Appeal and then to Supreme Court. So when I mentioned training, it's professional training. But as a judge, you have access also to professional training provided by the National Judicial Institute all across Canada in every province. And that every judge will follow that training as well.
Got it. Sir, you've got the last question.
Hi, I'm Clarence. I'm a student at the University of Ottawa, and I'm looking out at the entire future ahead of me, whether or not I do end up going to law school or not. And I'm seeing, climate change, technology, the rise of authoritarianism, and looking out, trying to plan a future. What should I pay attention to? What should young people be looking at or paying attention to when it comes to issues, when it comes to the way the world is moving from the vantage point of someone who is at a high position and has been doing this a long time?
One more reasons to become a lawyer or a jurist or somebody who can provide some help, because we need people. We need people with open mind. People young, they will get out of the university, but they will keep their options open and keep an open mind to any opportunity that will present to you. And very often, you never know what can happen. But if you keep an open mind, there are serious and very interesting opportunities that will be brought to you. And I urge you to continue to work hard, and because we need young people to deal with the new issues. Climate change is major for the next generation, but all kinds of challenges are in front of us, and we need people committed to do their best.
Thank you, Clarence. Okay, I've literally got about a minute left here, a couple of minutes left to ask two follow-ups that I want to circle back on. Access to justice, I know, is an important issue for you. You get hundreds of people every year who want to present at the Supreme Court, and to the best of my knowledge, I don't think you've taken any of them for people who want to represent themselves.
You may be right. There are very few anyways. So
Okay.
we have between 400 and 600 leave applications every year. And 20%, 25% of those are filed by self-represented litigant.
So would it be better for the court's reputation if, in terms of access to justice, if you took more cases from people who want to represent themselves?
Well, we have to take cases that deal with public interest, that deal with some kind of controversy amongst the Court of Appeal throughout the country, or in new legal issues. We're not a correction type, court. In other words, that's the function of the Court of Appeal.
So when people say, if I don't get my way, I'm going all the way to the Supreme Court of Canada.
Well, if they have a case of national interest, of public interest, a case that deals with a controversy in a legal issue, they will be heard. But if it's simply because they are not satisfied with a judgment, that might be an error by the first judge, well, the Court of Appeal will deal with that. But the Supreme Court of Canada does not deal with those issues.
Gotcha. My last question is, you have to retire at 75, which is a long way from now. But I guess the question is, do you intend to serve until then as Chief Justice?
Well, I go year after year. And as long as I have got the energy to do it, and I still have the trust of my colleagues, and if I am confident that I can do the job, I will stay.
How do you feel today?
I feel very good. Thank you.
Okay. Chief Justice, stand by for a second because we're going to do some thank yous here. First, I really want to thank this audience for being here, for coming out on a reasonably beautiful day here in the nation's capital. You could be doing other things, but we're grateful for your attendance, and in particular for those who asked questions today. Those were wonderful questions. I want to thank Mark Ford, who's responsible for getting our wonderful crew here to Ottawa and set up. You guys did a great job and made it all look seamless. I want to thank the National Arts Centre and its crew, who have been absolutely amazing to work with. I want to thank the Wilson Foundation. And this entire TVO Today live series is happening, and it's free, right? Nobody paid anything to be here today. This is free to the public, thanks to the generosity of Red Wilson. And if you want to see some of the other programs in this series, you can go to our special website for this. It's tvo.org/TVO Today Live. Or, of course, everything's on YouTube. So we're on YouTube as well, youtube.com/TVO Today. Want to thank Hillary Clark, who produces the TVO Today live series. Clarky, you to bomb. This was great today. And finally, I know all of you want to join me in thanking the 18th Chief Justice of Canada for spending so much time with us here in Ottawa this afternoon. Thank you, Chief Justice Richard Wagner. I'm Steve Paikin, and good night from the nation's capital. Good night, everybody.
TVO Today Live is made possible by the generous support of the Wilson Foundation.